Your Honor, there are several reasons why the order should not be lifted. The first reason why it should not be lifted is that we filed a verified pleading. A verified pleading is evidence. And I think the code section for that is, I had it was maybe 91110, but I can get it. So the complaint we filed is evidence. There has not been an answer, no verified answer. So that's all the court has to go on. The second reason we think the injunction should stand is because the law that made the term of the chairman 4 years resulted as a result of a lawsuit that Mr. Cook and some others filed against Randolph County and the Board of Education. The code section that gave Mr. Cook that 4-year term was pre-cleared by the Department of Justice. Now, the act that they are trying to pass, they're saying that it does not have to be pre-cleared. Well, at some point we'll get an answer to that because the act has been sent to the Justice Department and they have an analyst review it. Now, the reason I cited the Jenkins case because there the Supreme Judge panel basically said if it has not been pre-cleared, you can't enforce it. So that's another problem. The third problem they have with this is the case of Fulton et al. V. Baker. I've already cited it before. And basically, you know, in that case, the Supreme Court found that Section 2 of the Local Act meets the deposition of a bill of attainder. And what had happened there is that they had a procedure for filling vacancies. The county commission did. Well, they basically put Ms. Fulton in the seat. And while Ms. Fulton was in the seat, I guess a local legislature, just like here, introduced a law to change the way they did. And the Georgia Supreme Court basically said that, you know, you can pass the law, but it's unconstitutional because you're cutting her term. And they said that basically the law would be okay if it became effective after her term was up. But there's another problem with it also. By removing Mr. Cook from chairman by the end of his term, that he was legally appointed and elected, it inflicts punishment without a judicial trial. Basically, what had happened here is a legislature has decided we're going to remove Mr. Cook, and we're not going to give him any judicial trial. We ain't going to give a notice. We ain't going to give him a hearing. We're just going to pass this law, which applies only to him. And also, Your Honor, we get into an equal protection thing because it only applies to Mr. Cook. And in order to make my argument, I'm going to give the court a situation about another board, and I want to ask you, how is that board chairman different from Mr. Cook? The court is from the South Georgia Judicial Circuit, which includes Baker County. In 2008, Baker County School Board had an election where a majority of the school board members lost. At the beginning of the term, before the election, the board consisted of 3 white persons and 2 black persons. During the election, 3 incumbents lost, and 3 black female won seats, which would make the new board 4 black persons and 1 white person. Now, after that election, in November, December, the old board met where 3 people had been defeated. And they elected the only white person on the board to be the school board chair. They entered into a contract with the school attorney, who had never had a contract. And they entered into a contract with the superintendent for half-time work. Now, is it fair to Mr. Cook that what happened over there, I mean, what's the difference between him and the white chairman? The only difference is a legislature went to the legislature and got a bill to remove Mr. Cook. Mr. Cook has more right to be chairman than she did. I'm going to tell you why. The term of office fixed by Mr. Cook was law, okay? It was pretty clear by the Justice Department. Now, the 3 board members in November, they could not change that law. And I think the court knows that a charter provision can't be changed by a majority vote. It has to be changed by the legislature. And Your Honor, if it could be changed by the legislature, if it could be changed by 3 people voting on it, why did they have to go to the legislature to get it? And I think it answered that question. The second question is, the meeting on November 19th is not a good meeting. And the reason it's not a good meeting is because by the time they had the meeting, it had been canceled. And I think if the court looks at my exhibits to the amendment to the petition, it will show that the board members had been called and told that the meeting was canceled. In any event, even if the meeting were not canceled, they didn't do anything to post an agenda to say that they were having a meeting for the purpose of electing a school board chairman and vice chair. Also, if you look at my exhibits, on the April 6, 2009 meeting, Mr. Cook chaired that meeting. So our position is that they have not, first of all, legally, 563 is a retroactive law, and it's unconstitutional as applied to Mr. Cook based on the holding of Fulton v. Baker. Our second argument, I guess our first argument was that it had not been pre-cleared by the Justice Department. Our second argument is that it's unconstitutional as applied to Mr. Cook as a retroactive law, a bill of attainment. And our third argument is that Mr. Mott could not be chairperson because he was elected at an illegal meeting if you say he was elected, and we have challenged that meeting within 90 days. It happened on